Today, Vice President Kamala Harris did something no other vice president or president has ever done. She visited an abortion clinic. Harris traveled to a Planned Parenthood clinic in St. Paul, Minnesota, to highlight the stakes of the 2024 election. Even in a blue state like Minnesota, where Democrats control all the levers of state power and where reproductive freedoms are protected, a federal ban would nullify all of that. And the presumptive Republican nominee for president, whom Harris and Biden are running against, has expressed support for a nationwide ban. Democrats' bid to highlight the stakes here is only strengthened by what's happening elsewhere in the country. In Texas, basic access to contraception is now under attack. This week, a panel of appeals court judges upheld a Texas law requiring parental consent for minors to obtain contraception. And while this case might be about teens at present, it could also signal a fight ahead. At least one Supreme Court justice has already documented his desire to overturn the right to contraception among the population at large. Joining me now is Leah Littman, professor at the University of Michigan School of Law and one of the co-hosts of the great podcast Strict Scrutiny. And back with me is Melissa Murray, the other co-host, one of the other co-hosts, we're not going to leave Kate Shaw out, of Strict Scrutiny and NYU law professor. Leah, thank you for being here tonight. And Melissa, thank you for staying. Just don't ever leave. Leah, first, let's just talk about this Texas decision, right? Because I think there is some people are saying, oh, but this is just affirming a kind of general parental consent decree that exists in the state of Texas. But if you read it sort of in the real world, it sounds like they're coming for contraception here.
Absolutely, because you could have said the exact same thing when they began their war on abortion access, because initially, when they were attempting to restrict abortion, first they adopted laws that required parental consent for abortions, and then it was trying to enact laws that adopted additional restrictions on abortion providers, and then it was, well, how about adopting a law that requires spousal consent before obtaining abortions? And that was all part of a longer process that led to the court eventually overruling Roe versus Wade and ending the constitutional protections for abortion in Dobbs. And what we're seeing now is the beginning of the same thing happening for contraception, as Justice Thomas signaled in Dobbs that he wanted to happen more quickly than it seems like things are happening now.
It just feels like Clarence Thomas sends up a flare on like the crazy topic of his choice, and out there in the country, conservatives follow suit. I mean, do you think this is ultimately going to be, if not this case, a case about contraception is headed to the Supreme Court?
I think it is inevitable that contraception will go before the Supreme Court because, again, this isn't about simply forestalling abortion. I mean, if you wanted to end abortion, you would actually be in favor of expanding access to contraception to prevent unwanted pregnancies. It's not about abortion. It's not about preventing unwanted pregnancies. It's about controlling sexuality and, in particular, enforcing a set of gender roles on individuals like women who rely on abortion and birth control as means of controlling their reproductive capacity. And you're right. Justice Thomas is very much the intellectual genius behind this entire project. He often writes alone on the court. He did not get anyone to sign on to his concurrence in Dobbs. It doesn't matter because he has an army of former law clerks who are now sitting federal judges in places like the Fifth Circuit who hear these flares as they go up, listen to what he's saying, read his opinions, and then put them out in their own courts as part of the law of their circuits. That's what we're seeing in the Fifth Circuit. We've seen it before in the Sixth Circuit. Justice Thomas has been shepherding this completely bogus narrative that abortion is linked to the eugenics movement and has been used as a tool to deracinate the African-American community. No one else signed on to his concurrence in an opinion saying that, but then it began appearing in lower courts' opinions, and then it appeared in a footnote in Dobbs. So he is the sort of evil genius behind all of this. And when he's done for the night, he goes back to his office and strokes a hairless cat and prides himself on what he has done.
Talks about the end of bodily autonomy as we know it in this country. Leah, can you talk a little bit about Jonathan Mitchell, who is involved in this case, and Matthew Kacsmaryk, the judge whose name may be familiar to some viewers of this program because we talk about him a lot. He's done a great and inordinate amount of work in terms of furthering the conservative agenda through the courts.
Yeah, so he's a busy guy. He was the judge in the medication abortion case that the Supreme Court, the mifepristone case that the court is going to be hearing in a few weeks. He's a judge who effectively ordered a nationwide ban on medication abortion, one of the drugs used in the medication abortion protocol. He is also the judge in the Title X contraception case. He is also the judge where there was a multi-million-dollar lawsuit filed against Planned Parenthood in his court. And they are filing these cases before him, in particular his division, because they know, based on his track record, he was essentially appointed to do all of the things he's doing now, right? Making it more difficult to actually make medication abortion access available, now restricting access to contraception, and just outlining all of these theories that then some judges on the Fifth Circuit pick up on, and then they go up to the Supreme Court, and the Supreme Court is able to steadily move the law in a more conservative direction, even if they don't do everything that Judge Kaczmarek does, even if they don't do everything that Jonathan Mitchell asks them to do, they are still steadily moving the law away from access to contraception, access to reproductive freedom, access to bodily autonomy. And so that is, again, what Judge Kaczmarek was put on the bench to do, and that is what he is doing.
And Jonathan Mitchell is the guy that came up with the bounty hunter abortion law in Texas, right?
I mean, he is a busy guy. The bounty hunter abortion law in Texas, SB 8, which the Supreme Court allowed to go into effect well before Dobbs, essentially ending abortion access in the second largest state in the union before Dobbs did, a precursor of things to come. He was also the lawyer who argued the disqualification appeal before the United States Supreme Court for Donald Trump. And, we've talked about
the
this on our
14th Amendment,
podcast.
the 14th Amendment case.
We've talked about this endlessly on our podcast. We think he's auditioning to be our next attorney general.
Yeah, well, he has basically made statements, right, to the press indicating that he wants in the next Trump administration, the administration to begin enforcing the Comstock Act, a Victorian era law from the 1870s that now more than 100 Republicans have signed onto a brief that they say allows them to ban medication abortion without actually having to pass a new law. This is a theory that Jonathan Mitchell says, let's not talk about until after the election.
Well, and he's great at these kind of end runs around what the law says, right?
He's great around these end runs, around majoritarian preferences, because they realize there is unlikely to be majoritarian support for a national ban on abortion. So even if they are able to get control of Congress and the presidency, there would be considerable pushback. But all they need to enforce the Comstock Act is a Republican president with a Department of Justice willing to prioritize this as an enforcement priority. And they're in business. They will resuscitate this zombie law, and they will begin enforcing it, preventing the shipment in interstate commerce of any article that might be used for abortion. And that includes long-acting forms of contraception that they term abortifacients.
Well, I mean, and this is coming as they're talking about they are litigating IVF, right?
Yes.
Once you have sort of allowed Christian nationalism to sort of infuse your party platform to the degree that all interference with contraception, which is where life begins, should be unlawful and is unethical, then that sort of dictates what your party priorities are in terms of policy, Leah.
Yes, no, they have opened the door to this, because once you start saying states have a legitimate interest in just treating fetuses, unviable fetuses, as potential human beings, then that doesn't end with abortion. It extends to contraception, it extends to IVF, it extends to all other manners of reproductive health care. And so that's happening with the Alabama Supreme Court decision. And honestly, this was happening even before Dobbs. Melissa mentioned treating contraception as abortifacients. The Supreme Court in Hobby Lobby versus Burwell essentially said that some employers were entitled to believe and then act on their belief that some forms of contraception were abortifacients and therefore did not have to offer that form of health insurance coverage to their employees. So the seeds have already been planted, and they are just waiting, again, for the next Republican president, knowing that the Republican Supreme Court will let them get away with basically anything to test the limits of the law and try to bring a federal abortion ban to life without having to enact it into law.
That's why Kamala Harris was in Minnesota today. You could be in a blue state with Democrats controlling the state, have all the protections you think you need, but it matters who's sitting in the White House.